What's up, everyone? Welcome back to another video. Hope you are all doing well. Today, I'm going to be interviewing Chris Awad, who is an ex-sergeant with the Fort Bragg Police Department. And for those of you that are not aware, Fort Bragg is a city in Northern California in Mendocino County, back where I did my law enforcement time as well. I have had a lot of people, not a lot, a decent amount though, request that I do a story on Chris. He has kind of a interesting history on his right before his departure with the Fort Bragg Police Department. So we're going to be getting into what actually transpired with him and all the events that led to everything that happened with him. So thank you, Chris, for being willing to come on today and to discuss some of these things. I didn't want to tell the story for you. I figured that the best route to accomplish this goal here would just kind of let you tell your side. And then I know that we have some documentation and other things that we're going to show to kind of prove your case about what actually happened with some of these things. So yeah, thanks for being willing to come on and discuss it with me. Appreciate it.
Yeah, no problem. I appreciate you giving me the time to come on your platform here and say my side of the story and everything that happened. And, I think you're right. There's a lot of people wondering about what happened with me and why I just up and disappeared. And, so I feel like I kind of owe an explanation to the citizens of Fort Bragg that I interacted with. And, this is kind of the last step before I can close this chapter finally. So,
So
let's get into it.
Yeah, so there's a few different things obviously that I want to touch on with you. So one of the main things that when people have been contacting me about you, and that's something that I know that happened as well, is you were terminated from the Fort Bragg Police Department. And what I've been told, and what everyone else is under the assumption of or the impression of, is that it was because when you were still a cop with the Fort Bragg Police Department, you lied to get a girl out of a DUI, and that was the cause for your termination. And then obviously we're going to discuss something else surrounding your past and your history. Shortly after your termination there's been a lot of speculation and rumors that came up that people were stating that you were building and manufacturing just like a plethora or like an abundance of firearms, and selling them, also buying silencers. And basically, from my understanding, is that people had this impression that you were, I like to state that you're like Nicolas Cage of Lord of War, where you're just like a huge arms dealer. And then, so I want to get into that and clarify that, what actually happened there. And then the third thing is, it was brought to my attention by two different people that are affiliated with the City of Fort Bragg, that the city was illegally using funds in a way that they are not supposed to by law to pay for, well, essentially what was going to be your salary at the time when you were working there at the Fort Bragg Police Department in the role of, when you were an agent with the task force. So, and just to clarify with everybody really quick, I didn't know Chris very well during, we worked together a little bit here and there when he was in the task force and I was in Covelo. So we were cops, during the same time frame in Mendocino County. However, he was, mostly in Fort Bragg, and I was over an hour and a half away in the town that I was, dealing with. So I didn't really, know him too much or know anything about a lot of these situations. I kind of just stayed out of it, did my own thing. So that's the other reason why I didn't feel it was appropriate for me to discuss it, because I didn't know all the details. So for today's video, and we'll do this in a few different parts, like I told you already, why don't we go ahead and get into the DUI and how that happened with that girl.
Yeah, so we'll go way back, and again, this was years ago. So I was on patrol one night. I stopped this girl for a DUI. I give her a DUI. Right, she goes in later. She pleads guilty to it, starts taking her punishment. And so over the course of that, after that case was adjudicated, after she had pled guilty, and she was doing her punishment, we actually kind of became friends a little bit. And, over the course of time passed or whatever. And then she later learned that her DACA status would be affected by having a misdemeanor DUI on her record. So I told her, well, you know what, you like obviously learned your lesson. You're doing your DUI stuff. Let me go in and I'll talk to the DA and see, I'll give him my opinion on as to whether or not he should plead this down. At this time, we've had no romantical relationship or involvement at all. We're simply friends. The relationship is entirely platonic. Again, this is not a quid pro quo situation. It's just And it's actually quite common for officers to do that for citizens or people. And it's, you know, I've done it for multiple people, males, females, you know, it doesn't matter. My opinion is if you have learned your lesson and you're moving forward with your life and whatever, you should be given some more leniency toward the spirit of the law. Again, she had already pled to a DUI and was like almost completed with her punishment for the DUI. So I go in and I speak to the deputy district attorney at the time on the coast, Kevin Sisney, and I tell him everything, you know, like all the reasons as to why I think that if she brings this case back up, it should be considered to give her a wet and reckless instead. So also there, I never want her to get out of anything. Okay. I feel like a DUI standing alone and that being the only factor in and of itself, deportation is the punishment doesn't fit the crime, you know. And we're talking about someone who's been here pretty much their whole life. Like they immigrated over as a child, you know, so they built a life here. They have kids here. They have, you know, so for their DACA status to be affected, and basically what we're debating is words on a criminal history sheet. We're not debating actual crime and punishment. So anyways, I go in and I talk to the deputy district attorney, Kevin Sisney, and, you know, I tell him this and he kind of gives me the unofficial nod and says, you know, I'll take what you said into consideration. You know, to me, every time a district attorney's done that, usually you don't hear about it. And then the case pleads out how you recommended it anyways. And it's also common for deputy DAs to reach out to officers and ask their opinion on what should, you know, transpire with the case. What do you think? You know, that's happened numerous times. So anyways, I do this, and then a little bit later, I hear from her something, you know, we had a conversation, something to the extent of how she was talking to her public defender and whatnot. And I took from it that, you know, she was pretty elated that the wet and reckless was going to be offered to her. So I take it as, okay, this is going to be played out and a done deal, you know, but we're still set to go on the court case. I just hadn't got the cancellation yet. So anyways, during that time, I had gone away to a training, and she was down in the area, you know, and again, it was just a random happenstance. We weren't planning on meeting up out of town. She just happened to be in the same area I was. So she had like missed her flight or something. And she said, you know, hey, I missed my flight. Can I come hang out for a couple hours? Yeah, no problem. So we're kicking it. She comes over. We're kicking it. We bullshit, talk for a couple hours. She leaves. Nothing happens. In the process of that time, I start drinking a bunch of beers, and I get a text again, says, hey, you know, my flight got delayed or canceled, or I missed it or something. Can I come back and bullshit for a couple more hours? And I'm like, yeah, that's fine. Well, at this point, I'm hammered drunk, you know, and then so that, and again, I don't think neither her or I planned this to happen. You know, we did some stuff that we probably shouldn't. We didn't go all the way, but, you know, you have two single consenting adults, and, you know, some stuff happened that probably shouldn't.
And really quick, when that happened between you and her at the hotel, what was the status of the case at that point?
It was still active, but I was under
your portion was already done. Like the evidence was submitted, the report was already typed up and all that stuff, but it was still in the process, right? Of like in the court proceedings.
It hadn't gone to the court yet. It was just, you know, my impression of it was that she was going to be offered her offer. She was going to take it. And even her impression of it is, you know, once she got back from her trip, she was going to go in and plead to the wet and reckless, and it was going to be a done deal.
Gotcha.
So we both are kind of under the impression that this thing's going to plead out, you know, but I put the cart before the horse, and the reality is I should have never even let her come there. I should have never, you know, hindsight being 2020, you know, I understand the error in that, but again, I don't think it's even something that her and I intended to happen. You know, she came once before, and nothing happened like that. So anyways, after that happens, you know, like I said, we don't go all the way, but, you know, some stuff happened. Two single consenting adults in a relationship. But up until that point, our relationship was entirely platonic. Like it was completely a friendship, you know, and that's kind of like a key factor in this is like, you know, when I stopped her, I didn't know her. When I went and talked to the deputy district attorney, there was nothing like that even on the table. Like in between us, we were just friends, and I was just trying to be you know, go try to help her because I didn't feel that deportation was an appropriate punishment for a DUI. Now granted, DUIs are serious and whatnot, but she had already done a good portion of her punishment for the DUI. Again, way back when the incident happened, she had went in and just pled guilty to it. She threw herself on the sword, you know? And so that was kind of also a factor in my choice to go and try to speak to the district attorney on her behalf, was just how accountable she was. So we're not really debating crime and punishment. We're debating words on a criminal history sheet. So anyways, this happens. And then going down the line, you know, some time passes, and then I get a text from her saying, you know, Kevin left, exclamation point. Like, and I'm like, yeah, you know, I guess he's not there anymore from what I heard. And then the case got now the actual DA, Dave Eister, is handling this case. Okay, so she then texted me later on after that, and she said my deal went away because Dave Eister said it's against his policy. Now that's also another fact that I want to bring up, because if Cisney would have told me that it was against their policy, which he never did, I would have told her, hey, there's nothing I could do. We're going on this. It would have totally redirected the course of this. You know, at that point, I would have been like,
what was against their policy specifically regarding that?
Giving a wet and reckless to a DUI because of her BAC, which I think was like a 0.11 or something.
Okay.
Or some, I can't really be.
Oh, so when it reaches a certain threshold for the DA's office, they just under no circumstances at all will give a wet and reckless?
To be,
that's
just
what you were told.
That's just what I was told. You know, I'm not privy to the district attorney's office policy or whatever.
Right.
But she says, you know, Dave says it's against his policy. Okay. So anyways, I'm set to go on this. I'm like, well, you know, I know we're friends. I got to do what I got to do. And she understood, you know, that I had a job to do. So anyways, that trial ends up getting canceled. I think it gets canceled another time. And so, you know, we're fast forward quite a ways now from the actual incident of the crime to this, you know, do we get to this trial? And I get there, and it's not Dave Eister, it's Deputy District Attorney Melissa Weems, right? So we go on, you know, we go and they're trying to do jury selection. It's taking longer. I'm getting irritated that I'm sitting there all day. So yeah, I had kind of a shitty, piss poor attitude while I was there. And finally they get the jury selected, and I make a joke to Melissa Weems saying, well, you know, if I just don't remember anything, can we just go get some beers instead? And she says no or whatever, and we leave. But it was an entire joke. So I get up there and I do my testifying on day one or whatever, and I'm testifying to the facts. And this is a DUI where it wasn't one where someone was sloppy, falling over, drunk. You know, there was a couple tests she did really well on. The two middle tests she did really well on. What clued me into her drink, to the fact that she was driving under the influence, is that she had nystagmus and her internal clock test, and then the overwhelm objective symptoms, the smell of alcohol, you know, the red watery eyes, just the common things when someone's under the influence of alcohol, right? So anyways, I do my testimony on that day or whatever, and then the next day I show up for testimony, and I give my whole, you know, spiel or whatever on the stand there. And let me rewind back a little bit. So I get there that morning, and Melissa Weems was like, hey, there's a couple things that don't make sense in the report. You know, like, are these errors or what it is? And so one of them was the timeline. I had transposed the date and time of the incident by like an hour or something. And then The other one was the timeline that she was drinking that comes out in the preliminary questions on a DUI. So I says, yeah, you know, that's not right in the narrative, but it is right in the face pages. This and, you know, and whatnot. And normally for me, that's not a problem. You know, that's just the issue that you're going to have to own on the stand. Hey, I made an error in my report. She alerts me to two things, those two things. So, you know, going forward, we get through it, and I could tell, like, you know, I get through the, you know, and to be fair, like, I'm really pissed off because I'm there for 2 days on a on a DUI case. And also I'll rewind back to the first day. I had spent my time preparing for a pretty in-depth gang case, which was which involved violent assaults, and I had never testified as a gang expert before. So it was my first one, and I had written this 18622 supplemental. So I'd spent all my time preparing for that. And then on top of trying to learn how to be all the sergeant duties that I had just been tasked with. So, you know, I didn't really give much attention to this, the attention that I should have. So anyways, we discover there's errors in the report or whatever. And we go through and I give my testimony or whatever. And the next thing I know, Williams is coming at me hard on the stand, you know, and she finds discrepancy in the nystagmus portion of it where I write prior to 45-degree angle of onset. Now I'll rewind again to the fact that that's not how I used to write those reports. I used to write them with the approximate angle of onset or what it was, whether it was immediate nystagmus or, you know, whatever angle, because it does play a portion into what your blood alcohol content is. And that was inspired by a training from the district attorney's office, Kevin Cisney, which I later learned was not training that was approved by Eister. So he's doing this on his own. So anyways, you know, when we write reports, we use templates a lot of times. Okay, so in this template, I had left that in there. And in this particular report, I overlooked it and didn't pull it out. So anyways, she used that against me on the stand. And then I get this, you know, so we're leaving and I'm still joking with her. I'm like, man, you were harder on me than the public defender. And we get into the little district attorney's office there, and she just blows up, accuses me of trying to tank her case. I have a shitty attitude, which is true, you know, but I'm like, no, I'm not trying to tank your case. I'm trying to relay the facts of the case, you know. And she's like, nobody uses the words perfect or whatever. And I'm like, well,
so hold on. So you described the for the documents that you did send me, for the transcription, right? So you did state that she did well, or she did perfect on was it like walk and turn or one leg stand or something like that. One of the field sobriety tests.
I think it was the one leg stand, you know. And so when you
but did she do a perfect job?
Yeah, you know, to the best of my recollection at that time, she did.
Well, then how else are you supposed to articulate that fact? If it's perfect, it's perfect.
You just say what happened, which I did. And in every test, I say what happened. And then, you know, there was a couple like things that like in the test that like a couple minor details that when I gave my testimony, I gave a generalized, you know, testimony of what I observed during the FSTs. But like, so for example, on the Romberg, and this is one of the things that they're trying to bang me on, right? I say that she had a delayed internal clock test. You know, I was looking for 30 seconds. She opened her eyes and indicated she was finished after 37, but I didn't say on the stand that there was some slight swaying. So little minor portions of that, but every time that Melissa Weems prompted me to give a response in regard to that, like, well, it's also noted slight swaying, I would say, yeah, that's accurate. You know, there's some slight swaying in there, you know? So everything that she prompted me on, I agreed to. Like, I wasn't trying to leave.
And that just shows really quick. So that just shows that you were completely unprepared for, like, you didn't review your report prior. And that makes, I mean, every cop has done that. Like, so if you got prompted and she said like, hey, so you in your report, you said swing. And then on the stand, you said, no, I didn't. That's not true. Then obviously that's a lie. But the fact is, like, if you leave out little details like that, I've done it a million times. So has literally every other cop. And but the thing though, is that like all that information is on paper. So it's already there. Yes. So it's like, and that doesn't change. Nothing changes what's on that report. So I don't see what literally anything you say on the stand has to do with anything.
Right. So anyways, we get in this big blow up argument, you know, and I noticed also on the second day, DA investigator Mariano Guzman's there, right? So anyways, he's there. We have this blow up argument. I leave, stomp off all mad. I come back. I'm like, well, shit, I can't leave it like that. So I go back and I apologize to her. And I'm kind of like, okay, I got to figure out what the hell happened here because I don't want this shit to ever happen to me again. So then I figure out what the issues were. So I go back the next morning again and apologize to her and try to get to Melissa Weems and try to get some advice on, you know, like, how do you want these things prepared? Like, what is it? Because obviously what Sisney taught us ain't cutting it. So, you know, we talk a little bit and she says, okay, well, you know, I'll send you some information. She never did. But she's like, I'll let you know what the sentencing is. So anyways, she said the girl subsequently gets found guilty of a DUI. Right. So anyways, I go on, I'm like, okay, it's kind of a done deal now. I kind of brush it off. The next week I go back in to testify and I encounter Dave Eister in the DA's office on the coast. And he's kind of giving me this look, you know, and then I'm like, hey, Dave, what's going on? He's like, well, you know, what happened last week wasn't good. You know, some people are going to be looking into this or whatever. You'll be notified by your department. And at that point, I'm like, fuck, all right, here we go. We're going to get an IA on this. You know, and I'll backtrack and say, like, it's correct. I didn't tell Weems prior to going into trial about our, you know, my relationship to the girl because
well, that was the issue though. That was the main issue, is your omission that after the fact that you had that she had been arrested for DUI and all that stuff, that you had like hooked up with her or had a friendship.
Right.
Okay.
You know, and what it is, and like the word hook up, like we didn't actually hook up. We did some things, but but it's like, I understand what you're saying. Yeah. So my purpose in my thought process in that is that how is this a material fact or relevant to her innocence or guilt when it hadn't happened yet? When I arrested her, I didn't even know her, you know, had handled maybe like a vandalism for her or something else, you know, but didn't even know this person. So, anyways, you know, and I'm sitting there in that office and Dave, he's like, well, you know, you got to trust me and just keep going on doing like you're doing. I'm like, okay. And then, you know, but one thing kind of stuck out to me is like, so I understand you didn't agree with my decision to go forward on this case. And right then I kind of knew, I'm like, okay, man, like I disagreed with you and now this is what's happening. So anyways, later that day, I get served with IA paperwork or whatever. And, you know, so we go through the IAs and I do my interviews with Sergeant McLaughlin and I disclosed that we had a physical encounter and we had a friendship. You know, I don't go into specific details about it because he didn't ask for them. He didn't ask specifically what happened. You know, I give kind of a generalized answer in and of itself of, you know, but I disclosed the physical encounter that night that we had at the hotel. And so going forward, you know, I tell him that, I tell him basically the whole stuff about like, just like I told you, you know, but kind of a little more in depth about like my thought processes and stuff. So, you know, and I'll admit, like, one, I didn't reveal that to Melissa Weems. I didn't think it was relevant. And two, I had a shitty attitude. Three, I didn't prepare for court. And four, I wrote a shit report. I mean, so, you know, I take accountability for those things. I am definitely not innocent in this by any means or any regard. But what happened to me is unfair. So anyways, I get done with the IA process. I'm waiting. And then I get notified by Kevin Bailey notifies, I think, my attorney or whatever.
And Kevin Bailey is the
chief investigator of the DA's office.
Right.
So he notifies my attorney. Somehow I get notified. They want to do a Brady inquiry. Okay, what the fuck? So I go through, by the way, I'm going to also point out the fact that this interview is entirely voluntary. I don't have to do it. Okay, I don't have to talk to him. I don't have to say anything in regard to this to Kevin Bailey, but I'm trying to be transparent. I'm trying to be cooperative. So I do this interview and Bailey's interrogating me. He asked questions that McLaughlin doesn't ask. He wants the details. So I give him the the brutal details of the incident at the hotel, and I tell him my side. Anyways, that comes out as I lied to McLaughlin in regard to, they said that I said Cisney told me he was going to give her a wet and reckless. I never said that. I explained it in the IA consistently through over, I think, 2 interviews. Just like I explained it to you, he gave me the unofficial nod and, was under the impression, and then I had heard from her this, and whether I misconstrued that conversation or not, but I even recall texting back to her, congratulations, so whatever I took from that, but I was consistent in my statements the whole time. So now I'm a liar because I said that Cisney said this. I'm a liar because I didn't tell McLaughlin the details of what happened in the hotel room. And
yeah, but that's how internal affairs investigations interviews are supposed to be conducted. Like, why would you don't ever it's not a matter of omitting or lying. It's a matter of, that's an official interrogation at that point, realistically, because you're the suspect in that scenario, right? So
right,
you are asked direct questions and you provide direct answers. You're not going to be sitting there just like storytelling and just giving a bunch of random. Nobody does that.
And like when McLaughlin asked me, about the incident at the hotel, he's like, I give them that generalized answer, like, we had this encounter, but he then goes into a dating relationship, and I'm like, no, John, there's no dating relationship in this, and like then he moves on from the question. He doesn't inquire anymore.
Okay.
So, and my attorney, he's like, if he doesn't ask for specific information, you don't give it to him. You disclose the encounter. You're being honest about it. That is what it is. And in an IA investigation, you don't have to give specifics. You just have to answer the question at hand.
Yep.
So
yep.
You don't have to volunteer information.
Right.
Okay. So anyways, I get this. Then next thing I know, I'm getting put on an admin leave by Chief Nolte. And then like a month later after that, I get called down there and they serve me with that same, Nolte serves me with my termination paperwork.
And you were fired specifically for not disclosing the friendship.
Well, no, they fired me on all of the stuff that Bailey had said, right? But now we're going to go to, we had done a Skelly hearing and we had done this and that, or maybe the Skelly hadn't happened yet, but we'll get around to that because I didn't accept it lying down. I'm going to fight this. This is bullshit. I wasn't being dishonest. So they served me with that same type of bullshit that they served Amanda Carly with, Bailey does. And then, Nolte serves me my termination. So then we go to the arbitration, which is like almost a year or so after this, right? Because COVID had hit. And
for those that don't know, what's the arbitration?
So the arbitration, it's where I present my case and the city presents their case in front of an independent arbitrator, or like it would be, I guess, somewhat of like a judge, but not a legal judge. It's a person with legal background experience or whatever. And basically arbitration is a way to settle things, before court or whatever.
But you're basically showing that how you were not dishonest and did not lie.
Right.
They're going to try to prove that you're a liar.
Right. So through that, and I'm glad that I did it because it gave me evidence and it gave me some proof that, because when they write their termination stuff in their IA, they write it one-sided, completely one-sided. But we actually have facts, and in the facts of this, like, Melissa Weems testifies in our arbitration hearing, she says things to the extent of like, oh, I don't believe that Awad gave an opinion as to whether or not she was drinking and driving. And then my attorney's like, okay, let me read this opinion that he gave to you while he was on the stand that says, I formed the opinion that she was drinking and driving. You know what I mean? So we get all those things we caught. And I'm not saying either of them are liars, but one of them's lying because when we did the interview with Bailey, he was like, we talked to all 12 of the jurors and all 12 of them said they could tell that you had some kind of a relationship to the defendant, right? That's not true. So in the ARB transcripts, you can see that Weems, she testifies that it was one juror who said maybe 3 or 4, and then Bailey comes along and testifies that says Weems said it was all 12. Well, that's not true. So I don't know who's lying, but one of them is, you know.
Right.
And it's funny, like my attorney, he says to me through this, he's like, you know, when it was all said and done, the arbitrator sustained an omission, and the nail in the coffin was that I didn't tell Weems about the relationship prior to trial because I should have known that she needed to know that, you know. So either way, they upheld the termination, but all that other chicken shit they kind of threw out. He said something in relation to a nettlesome dispute or whatever, and they tried to come at me with when I said that the first I knew something was wrong was when we had that blow up in the office, but she had told me about the errors in the 2 reports. Like, to me, that's not something that's wrong. That's something that happens on a common basis. You know, what I'm talking about when I say that is I knew something was wrong with my testimony when she was blowing up at me. But I mean, you know, just to sum it all up, like, no, I did not try to get her off of the DUI. She was subsequently found guilty based upon my testimony. And yeah, I feel like I should have been punished? Absolutely. I should be accountable for the things that I did, but they're holding me accountable for things that I didn't. And I feel like it was kind of unfair and unjust in that regard.
Yeah, I'm going to pull up the documents here in a second that you showed me, or that you sent me, sorry, that shows exactly what you just stated, you know, in regards to Melissa and Melissa Weems and Kevin Bailey. But so you were also placed, though, during this on a Brady list, right, through the district attorney's office?
Well, he doesn't have a Brady list. So what he has is information that he can use under Brady if he wants to. But what it comes down to is that he basically says he's not going to prosecute any of your cases where you're a material witness, you know, and like Brady list doesn't necessarily mean, you know, lies. It just like a district attorney can Brady you for whatever he feels like. There's no discretion in it, or he has all the discretion in it. So it's just, it could be anything.
Well, traditionally it's reserved for lying in an official capacity, right? And they did this to Amanda Carley, the probation officer that I did in my last 3 videos. Dave Iser did the same thing to her, and he did the same thing to you. The thing with that list, though, is it's an imaginary, like, unicorn, dude. It doesn't exist. He's the only one that knows about it. It's probably on like some shitty, like piece of paper written in crayon, like in his desk or something. And it's really funny because we don't know who's on that list. I mean, I know some people that are on it that have still been allowed to testify in court that have not been called out for being on the Brady list.
Right.
And there's also a lot of people that, you know, like Quincy Cromer with the Mendocino County Sheriff's Office, who's a lieutenant now, that got fired from Ukiah PD for lying in an IA in an official capacity, right? So he can never be trusted again. He should never be allowed to be a cop again, because who's to say he's not, you know, ever going to lie again, right? Once a liar, always a liar. So, but he's not on that list. He can still testify. So the fact that, like, you know, you get put on, it's a bullshit list. We know that. It's just all fucking like.
Well, yeah, and they just did that article about how he's weaponized it against.
Mike Canella did that, yeah.
Yeah, you know, so I mean, I'm glad that some of this stuff's coming out now, you know, and then like you look at the Zeke Flatton, his RICO case, you know, there's a lot of good stuff about Eister in there that is starting to come out. And you know, I read some of that and it's good. You know, I'm glad that they're kind of banding together. Like I can recall
actually, hold on 1 second. Before we get into that, let me just pull up these documents really quick. You initially went in to speak to Kevin Bailey, said that that was a voluntary interview that you gave, that you did not have to give at all when he was, when they were questioning you about this. So this is Kevin, or this is your attorney talking to Kevin Bailey, right? So now when you conducted your interview with Chris Awad, was that a voluntary interview? Yes. Did he voluntarily come in and voluntarily answer your questions? Yes. Did he answer all the questions you asked? Did he refuse to answer any of them? No, he answered them all. Okay. And then the opinion piece that you stated earlier, where Melissa Weems had said that, so I don't think he gave an opinion that she, the girl that you arrested for DUI, was under the influence of alcohol while he was on the stand. Then the arbitrator, long story short, reads a quote from you that states clearly, you said, so based on my observations of her during the field sobriety.
That's my attorney. My attorney's Mr. Welty there.
Right, the attorney. Sorry, yeah, the attorney reads, but it's your quote. It's what you stated on the stand that gives your opinion, where you clearly state on the stand that she was under the influence of alcohol. And then you said, I just didn't know exactly how much, and then so the attorney's like, and so is the word possible or possibility anywhere in that answer in the question? No. And that response actually wasn't even a response to the question. And okay, so the attorney said, and so did you ask him for that opinion in the question above? No. And so unprompted, he provided this opinion that I just read to you. Is that correct? That's correct. Okay, so long story short, she said at the very top, you didn't give it. I don't think he gave an opinion on that. And then he clearly reads back what you stated on the stand where you gave an opinion. And then he's like, so that was the opinion, right? And then she's like, yeah.
Yeah.
Right? Okay.
Yeah.
That's solid.
Now let me ask you that, Trent, when you read that, does that sound like I'm trying to make someone not guilty of drinking and driving?
No, it doesn't at all. And I'm gonna give my opinion on this too at the conclusion of this, but no, like, and that goes into this next piece too, where Melissa Weems is asked. Oh man, this is small as hell. Sorry, everybody. I'm like a boomer when it comes to. Okay. So, and then your attorney, Mr. Welty, when asking Melissa Weems, where she, I believe your earlier testimony was that you had a conversation with one juror after the verdict, and that juror indicated there was some other jurors that were wondering if there was some kind of relationship between you, Awad, and the suspect. That's correct. And did he ever say it was all 12 jurors? He did not give me a number, so I'm not sure how many of the jury pool. And then, as you described earlier, it seemed like it was some sub portion of the jury. Is that, yeah, that's my recollection. I don't know if it was a majority. I don't know if it was 3 or 4. And so she said that at some point in time during this, that it had been all 12, or that was Kevin Bailey actually that said all 12.
Kevin Bailey says all 12.
Yeah, so she said 3 or 4,
right.
But she has no idea what the number is. And clearly she didn't take the time to get that not crucial, but an important piece of evidence against you. Because you want to know that. How many people specifically, jury member, believe that Mr. Awad had a relationship with this girl? So obviously she didn't, that wasn't very, it wasn't important enough to her as she made it seem like it was, I guess. And then this is your attorney
questioning Kevin Bailey.
Questioning Kevin Bailey about that same thing about the jury. So, right, and your answer says a single juror said that everyone on the jury felt that there was a relationship. And then Kevin's like, correct. And then the attorney. So my question is, who told you that a juror said everybody on the jury felt there was a relationship? Weems. And what would surprise you if Weems' testimony today was that juror said some portion of the jury felt that way, and that she was not told that the whole jury felt that way? Not at all. Why not? Because again, I'm paraphrasing a conversation that I wasn't part of. Could I have gotten it wrong? I could have, yeah. What was Officer Awad charged with any kind of perjury charge as a result of his testimony in this case, the DUI case? No, not to my knowledge, no. So he's saying that he got something totally wrong in his testimony. He just said correct, yet that was the whole thing. And then now he's saying I could have got it wrong. It is what it is. It's okay for me to get stuff wrong, but it's not okay for Chris Awad to get his report wrong because he was improperly prepared. But it's okay for Melissa Weems to or for him to just generate this information that it was all of the the entire jury. The other part that I thought was important on this too is that you were not convicted of a perjury charge, meaning you did not lie on the stand. You did not lie under oath. That they weren't able to substantiate any of that. Well, it didn't happen, you know what I mean? But so that is very important, because if you are a documented liar, they definitely would have charged you with that felony the penal code section for that, because it was they went out of their way to do this whole thing and to get you terminated. So yeah, they couldn't.
They're not holding anything back, but that I didn't lie on the stand. I didn't lie in any regard to this. I have admitted what I did, and what I omitted is not one. It's not a lie. It's an omission, and I didn't feel it was relevant. Hindsight being 2020, yeah, maybe I should have just told her about it. Maybe it would have avoided all this. I don't know. But my point being is, like, clearly in that last part that you showed, clearly either Weems lied to Bailey or Bailey's lying to us. Someone's lying, right?
Well, and then they are, but if they really quick, if they get it wrong though, but that's what I'm saying. It's okay for them to get stuff wrong. But again, you answered every single question that was asked of you during all this whole process. When you were on the stand, yeah, you had to get prompted, but so what? I've had to get prompted for so many of my cases. Every cop does at some point. You have to get, because we have so many damn cases to go over, right?
Right.
So it's like if you get prompted and you give the truth and factual answer, which Weems already admitted to, when prompted, you did provide the truth and an answer. So you're not lying. And so she's saying you're tanking the case, but if you were tanking the case, like we've said a couple times already, I'm kind of like beating a dead horse here. When prompted, you would have given false testimony, right? But that was never the issue. They never got brought up at all because you didn't do that. Also, shit, what was I gonna say? Yeah, it's just I don't know, man. I mean,
I probably like I said, I mean, in relation to the IA or whatever, like I would have been better off lying to the investigators. If I would have lied through this, if I would have lied that we ever had a relationship or lied my way through it, I would still be a cop. That's the that's the
right.
thing.
And you didn't have to provide that information. That girl,
I did not have to speak to Bailey. No,
that girl was never going to tell them that you guys had any sort of like friendship or anything like that. So
right. And in the IA, when both McLaughlin and Bailey interview her, they have to tell her, look, Awad already told us what happened. And then she tells, and she's like, yeah, that happened, So it's like she's not being forthcoming, and when she answers to McLaughlin about what happened, she answers like I did. She doesn't give graphic detail because he never asked for it. So that's the thing is like they paint this picture of you, and it's like, man, now that things are coming out, like I said, like we were talking earlier, that article about the weaponized Brady system, like, and then you have Zeke Flatten's RICO case that's got a lot of good stuff, about Eyster in it, and I'm glad that these growers and these people are kind of standing up, being like, hey, we don't think it's right that we have to deliver 50 grand in cash to the back of the courthouse in a paper bag.
Oh, say that story that you told me before.
Right. So when it was one of the first cases I did in the task force, we had got a request from the Department of Justice, California DOJ, to go scoop up these guns from this guy in Potter Valley. And so we go there and we contact the guy, we interact with the guy, myself and my commander at that time, and we tell him why we're there, and that he needs to surrender his weapons to us. And he goes, because he had been convicted of a the DOJ, sees that he had been convicted of a felony and he's not allowed to possess firearms. And we know he has these guns. And he says, whoa, wait, what are you guys even doing here? I don't have a felony. I bought the misdemeanor. And I think both me and my commander, like at the time, looked right at each other and almost simultaneously said, what the fuck do you mean you bought the misdemeanor? He's like, no, I did. I gave the Eyster 50 grand and he was going to make my, keep in mind the felony that we're talking about is cultivation of marijuana for sale. Right. So it's a marijuana deal. And he's like, no, I gave him 50 grand, and he's getting kind of pissed because he wrote a check or did whatever for 50 grand to Eyster for a misdemeanor. And I'm like, man, and that was my first kind of clue, is like, I'm not aware you can buy a misdemeanor, and even and I know that Judge Brennan and Eyster have had go rounds or whatever, but Brennan says it and he's right. I don't think that you can offer someone to pay money for a misdemeanor. Like that's kind of, wrong. And it is like, and then when you look at the root of it,
kind of like an extortion situation, man.
Right. And it's,
almost.
you're telling me, like, when you look at the root of it, it's like, okay, so you've taken two laws out of the health and safety code to combine them to suit your agenda to get, and all those stories that have come out, cash in the back door or whatever.
Yeah.
I was unaware that a district attorney had that type of authority, and then it's like, they come at me for, like, oh, you have this omission. Well, let's talk about some shit that they omit. Okay. Like they put this out there. Oh, we have a 98% prosecution rate. Yeah. 98% of the fucking cases that you take. I know that in my department, we documented every DA declined to prosecute, and like recently there was that fireman that got convicted of rape. And
From the coast, right? From Fort
from
Bragg.
the coast, right? So the simple reality is I had him dead to rights on that very same crime, same MO, everything, couple years earlier. But it was declined to prosecute. So these further rapes that happened by the suspect didn't have to happen, you know? And I mean, yeah, I mean, I had him caught dead to rights. So it's just one of those deals, you know. I would be interested to know the statistics of, and I don't know if you can, I don't know if that can be pulled or whatever, but I know that my department kept track of it. Everyone that he would kick back declined to prosecute. You know, there was a kidnapping victim, right? And this guy had tried to grab this girl and put her inside of a white van, right? When they found the guy, this was in Fort Bragg, they found the guy, and inside of the back of his van was a mattress, duct tape, rope. He's had kind of a history in Humboldt County of, you know, this type of kind of creepy behavior. I didn't prosecute it. So, I mean, and that was part of my frustration that day too. Trent sitting there, you know, because one of the DV victims had come in, was like, how is he out? You know, and it's just, so yeah, it's the percentage of the cases they take, not 98% of all of them, you know. Granted, I'm not gonna say there's some damn good deputy district attorneys in there who work really hard, you know.
Right.
Some of them that I've interacted with, they're good people, you know. So,
yeah, and I can fully vouch for you on the lack of, the 98%. That's not real. That's not a real number at all. I mean, I experienced a lot of that as well. A lot of cases that I was putting together that were, you know, DV stuff, or you know, big time quality of life issues, serial burglaries, and you know, other things, or even more hardcore stuff, you know, involving weapons and things like that, assault with a deadly weapon, you know, stuff with guns, and you would get that notification, like decline to prosecute, when you have all the evidence. You spend hours and hours and hours putting together this case, and you do become, and everybody experienced that in that county. Everybody I worked with, you know, there was a cop, and it's like you become jaded and pessimistic in regards to some of these cases. And so I can understand, the general citizens probably can't, but I can fully understand, like, when you go in for you know, I know that there's this element that, you know, this girl, but at the same time, when you go in for this DUI case, you're going to go through the motions. You're not really going to give a fuck, because these things happen so much that it's kind of, you at eventually, regardless of if you want to or not. I'm not saying this is a good thing, this is not a good thing, but you stop caring as much about these things. You stop putting in the work that you were, and you shouldn't do that. I'm not saying it's right. I'm not saying it's okay to do these things. I'm just saying this is the hard reality of what goes into all this stuff, right? And, you know, it's like when people go, well, you guys, cops should always care and always do all this work. And I'm just like, yeah, I agree with you. But at the same time, this is just like how it goes, right? We're human beings too. We feel anger, we feel, you know, sadness, we feel, you know, everything else. And so when we're busting our ass trying to keep the community a safer place and put actual bad people, you know, have them incarcerated, you know, and that shit doesn't get done, you know. So realistically, I'd say if you did a total of all the cases, and they, you know, I'd say that number is probably closer to like 40%, bro. You know what I mean? It's not
even if that, you know,
even if that. But, and to go back really quick to you, so they came at you with their so they said, you know, that per our policy that at the DA's office, we're not going to do a wet and reckless, which is a very, very common charge to go to from a DUI, as long as somebody doesn't have, like, you know, I mean, you get a decent attorney, you don't have a major criminal history or anything like that. Now, I'm not saying DUIs are a good thing. They end people's lives. They are, you know, they can be horrific. It's a big time. It's a big deal. But so he's saying that we don't do this yet. We will take, you know, cash in a brown paper bag and not give a receipt to these people and let them buy off misdemeanors. That's a policy of the district attorney's office there. That's already proven too. They've already had numerous people at this point through this RICO case that's still going on in Mendocino County, that has not gone away at all, that have come forward, numerous, to prove all of those allegations. Like, that's a proven fact, right there. And in my opinion, that is illegal as well. Like, I share Judge Brennan's opinion on that too. And like you said, I don't know how you can, he did combine those two, Eister combined those two health and safety codes, but it's like, I didn't know that district attorneys were allowed to make laws like that, right? And then also, if it begs the question, like, if you're going to be taking, 30,000, 40,000, 50,000, some cases I've heard $100,000 and not give any documentation into like, okay, you give me this money, this is your receipt, or this is the proof that you're doing this, and now you're buying a lesser crime. And how they, but how do we know where that money goes if it's not documented? And it's like, they phrase it in a way, and I've read it, they say it's in the best interest of justice and taxpayer money, to not go through the court system and have a jury trial and all these sorts of things. That's why they're like, well, we'll just pay us, and then instead of spending taxpayer money or whatever else and wasting everybody's time, we'll use this money that's given to us by this grower that's going to buy a lesser charge and then put it back into the community, right?
Right. And that lesser charge that you buy is on top of all of the shit that gets seized, right? So if we would go in and we would seize your boat, your car, anything that we thought was ill-gotten funds or purchased with ill-gotten funds, we'd seize that too. And so not only do you have to pay that fee, but you have to buy that stuff back from the district attorney's office, your own shit,
Yeah.
You have to buy that back. So that's all. I mean, yeah, it's at a discounted rate. Otherwise you forfeit it and they're going to auction it off and whatever. But yeah, then you have to buy your own shit back too. And I mean, it's kind of it's an influx of money, pouring into the coffers there. And it's just kind of funny how all of that works, and then as Prop 64 came out, that stuff kind of started to dry up, but
and just to go back really quick, just to close this out, so we don't draw this one on super long. I know we're going to do 2 additional parts to this. But in terms of what happened to you, in terms of this termination, just, I, in my opinion, I have no problem stating this either. I don't think what you did, like it's documented, man. Like every question you got asked, you got prompted, you provided an answer. They didn't perjure you because you didn't commit perjury. You didn't lie under oath or anything like that. All you did was, at the end of the day, it was not, you omitted, and they considered that the same thing as lying, that relationship. But, and I agree with you that it's not relevant to the case whatsoever, because you didn't taint the case at all. You everything that you got asked, you answered appropriately. So I think that you should have been there. Yeah, sure. Yeah. What you said, I agree with you. Like, was it wrong? Yeah. Should you have done it? No. Should you have been punished? Yeah. Did it warrant you losing your entire career over for that? Based on what we know about what all those other cops that are still walking around that have done? Absolutely not. So your chief there, John Nolte, really, in my opinion, shit the bed on that one. And that was not an appropriate punishment, clearly. And I know this from personal experience too. When you go against Dave Eister, like, you're going to have a bad day, right? That too. We've seen it with a lot of other people that we know. That's just how it goes. You owned up to it, like you've stated multiple times. You knew it was wrong, and it's like, well, hindsight 2020, what are you going to do now? And at the time, you were trying to help out a friend. I also want to bring up that point too. I've done that so many times. And you're right. It is common practice for deputy district attorneys to contact you and say, like, hey, they want your advice on your case, because you did the entire investigation, especially if it's super in depth, or the person. You've had multiple contacts with them, like, hey, so what do you think? What's your advice on this case? What do you think we should be going for with this? I've had that so many times. So it's like, how is it okay for me to, and usually they will take what you say into consideration, but it's like, how's that okay for me to do that? But when you do it, and also Mendocino County is a small place, man. I've arrested people I knew. I didn't say that I knew them. Right. You know what I'm saying? And nothing came of it, and it's like, I didn't know that, and I understand they're saying it's like some sort of ethical issue that you should always disclose it. But in my opinion, based on the circumstances, depending on what it is, it's not always common sense to do that. It didn't make any sense. Like, if you had, padded the investigation in some way and you knew her prior, that's a completely different story. You should be, charged with everything you can for that. But when somebody, it's like, like I said, I've known lots of people that I've had interactions with as a cop because I grew up in Ukiah, and it's like, that happens sometimes. But I didn't know that there was a law, policy, or anything else that states we shall disclose all prior relationships when going into court. And like you said, it's if it has a bearing on the case, yes, you absolutely should. When it has nothing to do with anything, which it does not in this case, clearly, like, she got found guilty. Nothing you said on the stand, which was all truths and facts based, you had to get prompted, but so fucking what? that had no difference. She still blew in the breathalyzer. The receipt was there with her blood alcohol content. There's no disputing that. Your report was still done. There's no disputing the words on the report. And in my opinion, reading reports in court was always a joke. You know what I'm saying? It's like, this is what happened. Why do you guys need me to come in? Just read it amongst yourselves and then, decide what you're going to do in terms of sentencing. Why do I have to come in and like read you like a book report that you've already read? You know what I mean? Like, I understand like whatever. I'm just being a smart ass, obviously, but
right. And again, the FST portions of that's my perception, and I had, for me, when I would do FSTs, I gave a lot of allowance of stuff because to me, I wanted to give people the benefit of the doubt. I mean, one of the factors in this case too, she was wearing heels when she did her test. I've never, or actually, it's a long story, but we used to do this dance in high school and we would dress up as bands and lip sync or whatever, but I had to wear heels for that. And I'll tell you what, I couldn't walk 2 feet, let alone do the walk and turn and that kind of stuff. And she did it, damn near perfectly, really, in my opinion. I mean, there was a little stumble on the turn and you got some, on like 3 of the steps, a minor gappage, that to me is a perfect test.
Well, again, and how else are you supposed to articulate a perfect
right.
test? I've done
exactly.
FSTs, and when I get asked and they say, how did they, in your opinion, what was their, how well did they do on this? I say they did well, or they did horrible. And then, they're going to ask you further, can you elaborate? But when you go on the stand, and it's like, it seems like Melissa Weems wanted you to go out of your way to help her case, to win her case, because they go off of stats. They want that guilty conviction, right? They want the jury to say this person is guilty because it's a benefit for them. It's part of their 98% bullshit that is non-existent. But it's like she got mad because you weren't like going out of your way to provide her this information. But it's like, if you did that same shit that she wanted you to do to the defense attorney, I guarantee you would have had, like, she would have had you in her office and she would have told Dave Eister about it too. And then that would have been a whole separate conversation about trying to help out in any case, like the defense, because you're split, and it's like, but so that's a direct bias right there, in my opinion. You know what I'm saying? And there's a difference between holding back information and legitimately just not reading your report. And I don't know the time frame. Like sometimes these things take like 6, 7, 8 months, sometimes 2 years to go to court. And it's like, I didn't review it. I don't remember shit because I've done all these things in the meantime, right? So I agree. Like I said, long story short, I think that it was wrong to some degree. Okay. Were you out there like committing heinous felonies like the entire admin at the Mendocino County, or the Kevin Murray thing, or the Noble thing? I mean, no, you weren't. I think you got screwed over, and I think that all these rumors that have circulated regarding you in regards to this case, like obviously, unfounded, right?
Right. And so it did lead to me surrendering my post certificate. But if it's good with you, I want to talk about why in the third video, or in the upcoming videos, so I can kind of explain why I did that, because I currently am the first one to do it. And I'm the only one on that list, and I gave it up myself. So if we could table that to the last one.
Yeah. So just so really quick. So just explain what that is, the post certificate.
So a post certificate is the certificate that allows you to, it certifies you as a peace officer in California, and post is short for Police Officer Standards and Training. It's a governing organization. Well, with the addition of SB2, they're going to be reviewing a lot of IAs, and I would encourage the cops to really read that because it's very limiting. But one of those things is they can review it and revoke your post certificate. Well, I have no desire to be a cop and whatever, and we'll get into a little more.
We'll talk about that later.
Yeah, we'll talk about that later. But for me, I'm not even saying they would take my post certificate away. I just don't want shit to do with it, so I gave it back to them. But we'll elaborate further as to why later.
Yeah, no, I just wanted but basically, when somebody surrenders it, or not even surrenders it, when it gets revoked against their will, then they can no longer be a peace officer. Is basically
in the state of California.
In the state of California, yeah. So I just wanted to but basically, if you commit a felony, you lie in official capacity, there's some categories of things that it falls under for that new SB2, whatever, that Gavin Newsom passed in 2021. If you fall under those things, then you're liable to lose your post certificate, and
Yeah, and there's a lot more in it than that too. I mean, you can't even resign in lieu of termination anymore. So once an investigation is and this is stuff for the cops out there who are still working, you know, once that once the investigation is initiated, the department can finish it with or without your statement. Whereas back in the day, um it used to be that, you know, they initiate the investigation and you say, all right, well, fuck you, I'm out, and you resign. They don't complete it. It's an incomplete investigation.
Yeah.
Now they complete it without your testimony and you still get, you know, put to the ringer for it. So there's no resign in lieu of anymore. It's that shit's done. So
Bro, all the
uh,
lieutenants at the sheriff's office there are so grateful, I bet, that they were not when they went through all their stuff because they all got to quit in lieu of, or whatever. It,
and that's
it wasn't around for their day because they would be out of a job for sure.
yeah, and that's effective January 1, 2023. So, you know, going forward for those guys still on the beat, you know, I'll say this too. Um, you know, the what happened with me and my mistakes are not a reflection on the Fort Bragg Police Department. You know, that's a great group of individuals, very dedicated to the community. They have an excellent police department there of good, honorable folks. So, you know, I messed up, but don't let my mistakes reflect on them. But what I'm talking about is like for those cops that are still working, you know, and I'll say this about, you know, all the cops pretty much that I've interacted with, the, you know, the beat cops, the guys on the street, they're all good, honorable, honest, hardworking folks, you know. So this is for them. Like, really read Senate Bill 2 because there's some stuff in there that, like, it's very limiting. I mean, I can see the path that they're taking. And to me, it's like there's not going to be any police officers in California before long if they when they keep passing stuff like this. It like it Oh, and another thing too is it's a direct SB2 is a direct violation of your POBAR rights, right? So you could go, and the way IAs work, they have to open it and close it within a year, okay? And you have to receive a punishment. And once that punishment is given to you, that's it. They can't punish you anymore for that incident, right?
Right.
Well, what post can do is they can get a hold of your IA because your department has to send it to them, and they can revoke your certificate regardless of what your department said or found or sustained or didn't sustain. And then you have to go before a board of like 7 citizens, you know, to justify your shit. So that's, you know, that's out there, and it, you know, they'll give you the legal updates and stuff, but really read that legislature or the legislation that they just passed, because it's pretty damning to police officers. You know, they can't yeah, it takes like the whole all resign in lieu of, and then this is dead, that goes away. So
Well, it's a benefit in terms of getting rid of the corrupt ones permanently, and then it can be potentially a disservice to those that are doing the right thing, right? So, uh,
right.
because of the right situation. So yeah, we're pretty much at time here. So yeah, so next video, so we got that out of the way. So the next one we do, we'll cover the that stuff that I uncovered about the city of Fort Bragg with their, in the what it looks like to me like illegal use of funds. And then after that, we'll do the raid, the feds that hit your house and did the search warrant on your house and stuff like that. So we'll go
Right.
ahead and end it here and get it going in the next one.
All right, Trent, thanks, man. We'll talk to you soon.